A motion to suppress evidence is when we ask the court to exclude evidence that the police obtained by way of an illegal search or seizure. It's grounded in the Fourth Amendment of the U.S. Constitution and Penal Code 1538.5. And really there's three typical scenarios when a judge will grant a suppression motion. One is where the police searched you without a warrant or without probable cause. The second is where the police had a warrant, but the warrant turned out to be defective. So for example, maybe the police provide misleading information to a judge in order to secure a warrant. Well, we can go and attack the warrant itself. And the third situation is where the police have a warrant, even a valid warrant, but their search exceeds the scope of the warrant. So maybe they have a warrant to search your home for stolen bicycles, but they go in and they start searching in kitchen drawers and jewelry boxes, places where they're obviously not going to find bicycles. In that situation, they've acted outside the scope of the warrant. Now, people ask me, when can I bring a suppression motion? And the answer is, in a felony case, there are two times when you can run your suppression motion. One is at the preliminary hearing, as part of the preliminary hearing. The other is during the pretrial phase, which means after the preliminary hearing but before jury trial. Now, if you run the suppression motion at preliminary hearing, that's your only chance to do it. You won't get a chance at pretrial. So it's a strategic decision that the lawyer has to make whether the prelim judge or the pretrial judge is more likely to grant the motion. In a misdemeanor case, there is no preliminary hearing, so a suppression motion is only run during the pretrial phase. Now, when we do a suppression motion, we start by interviewing our client, listening to our client's story. Then we go and do an independent investigation of the facts. Then we write a written motion of points and authorities of law for the judge. Then we have a hearing in court where we bring in the police officers and cross-examine them and try to discredit them and find inconsistencies in their story. Then ultimately, the prosecutor argues to the judge and we argue to the judge, and the judge makes a decision. Now, if the judge rules in our favor and grants our motion, then usually that means he or she will exclude evidence from court. And most of the time, that means that the case ultimately gets dismissed. So it's a great outcome for the client. We had a case where our client was pulled over and arrested for DUI, and the police found cocaine in his car. Now, the police officer said that he pulled our client over because he saw our client roll through a stop sign, do a sort of California stop. We went to the location of the incident, and we went to exactly where the police officer said he was when he saw this. We took photographs, we took video, and we were able to show that the police officer could not have seen the intersection from his vantage point, and therefore could not have seen our client roll through the stop sign. When we presented this to the judge granted our suppression motion, and the entire case was thrown out of court. If you're facing criminal charges here in California, we invite you to contact us 24/7 here at Schaus Law Group. We may be able to get the charges reduced or dismissed.